Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Edward Elgar Publishing. They're an independent firm of publishers based in Cheltenham in Gloucestershire. Now, they produce a lot of very high quality work, and this one is on arbitration. It's called Rethinking International Commercial Arbitration Towards Default Arbitration. It's been written by Gilles Cuniberti, a professor from Luxembourg University. It's available as a book and an ebook. Elizabeth and I gave this book some thought and had a discussion about it. It's part of the Rethinking series from Elgar, and we've come up with a title for our book review as follows: A refreshing statement on arbitration at a period of substantial commercial change. And that's actually where we are at the moment. Let's have a look at the book first of all. It's a hardback. There we go. That's the front. There's the spine, and then you can see the back. There's quite a lot of information on the back. It's part of the Rethinking Law series, as I've said. It runs to something approaching 250 pages. The index is by page numbering, which you can see there. And as to be expected with all of the Elgar books, it's a substantial work of law. Now, the selected bibliography is actually, fortunately you'd be pleased to hear, a little bit short than normal. The front of the book, we then have the actual front page itself, which is Rethinking International Commercial Arbitration. That's the actual Rethinking series, which is listed there. Then you've got some detail about the availability of the book at Elgaronline. It's in their law subject collection, and of course it is available as an ebook. Then you can see the contents section, and then running over, you can see in total there are 7 different parts to the book itself, with various chapter headings, 13 in total. There's a nice dedication, which I will leave you to see there. And then you've got the introduction. You've got a standard structure with a lot of footnoting. And you do have a little bit of subheading going on in it, but there's no paragraph numbering as such, but there is a lot of footnoting. It's a very interesting argument that he's putting forward. And in this short review, let me explain what I think the book is about and why it's important at the moment. The Rethinking Law series from Elgar maintains their tremendous scholastic record with this complex and detailed examination of current thinking from Professor Cuniberti at the University of Luxembourg. And as the publishers rightly comment, the subject, and I'm using some quotes here, the subject of arbitration is rightly seen today as the normal and preferred mode for resolving international commercial disputes because of the way it conducts its business. And that, of course, is across the board. It's a global issue. This is, as I say, therefore, more important than ever with the continual movement towards globalisation in an uncertain post-Brexit world. And, of course, the legal mechanism of arbitration presents an essential advantage over national courts by offering neutrality of adjudication, but is currently only available where both parties have consented to it. And of course, I say that position does, of course, raise some problems which a court judgment doesn't. Now, it's rightly described as an innovative book, and what Cuniberti is setting forward here is a fundamental rethink whereby arbitration should become the default mode of resolution in international commercial disputes. It is, of course, a question we will continue to consider, whereby all forms of dispute resolution can be used to avoid the law courts. And that, of course, is the whole preferred method. Certainly the judiciary would prefer to do it that way. And the basic reason is because it's better to have something agreed rather than imposed on people. Because if it's imposed, the parties won't like it. Whereas if it's agreed, there is a modicum of consensus. At least that's the theory. Now, the author starts his submission with a review of the most important arguments against this default mode proposal, and in response to them, he concentrates on addressing the issue of the legitimacy of arbitrators and the compatibility of the idea with guarantees afforded by European human rights law and US constitutional law. And we feel it's probably a most important and useful contribution to what remains a continuing debate on dispute resolution. It's by no means clear as to how many people will go for dispute resolution rather than a proper hearing. But the problem I have, certainly as counsel, is by the time people come to me, the time for talking is basically over and they want their day in court quite often. And I'm afraid that is the reality of the situation. Let me go back anyway to the book. Cuniberti then discusses several models of non-consensual arbitration, which is always, of course, a difficult problem. He concludes that it could be implemented, saying it could afford neutral adjudication in disputes between parties originating from different jurisdictions. That would be, therefore, to offer an additional alternative forum in the doctrine of forum non-conveniens, or to save judicial costs. And that basically, of course, is another very important aspect of why this sort of resolution would be the best way forward. Elgar, I think, are to be congratulated for publishing this first dedicated exploration into a groundbreaking concept of default arbitration. And it's with us, it's going to stay with us, so let's look at the options that we've got. We feel then that rethinking international commercial arbitration towards default arbitration itself will be of great interest to scholars, students and practitioners in arbitration and international litigation, because we've found that it offers both a fresh and contemporary view of modern adjudication, which will clearly expand in the years to come. And the publication date is 2017. Let's just have a quick look at the book again. There's the front of it there. You can see the cover, a bit grey. There's the spine and then there's the back. And just opening it in the middle, the proposed model, chapter 9, that's part 5, models of default administration. And you see he's thought it through very, very carefully indeed. And as I say, I find the information that has been given here very, very useful. The proposed model, actually, chapter 9, goes on for some considerable good because it is really probably the heart of the book itself. Anyway, Professor Cuniberti is to be congratulated very much indeed for producing this work. And I think because of the nature of where we are going at the moment, this Rethinking Law series by Elgar is a great contribution to the continuing debates that we're going to have in the 21st century. So thank you to all concerned. Bye-bye.